Welcome back to the House Judiciary Committee, and we're going to turn to S12, the sealing bill, and we'll start by hearing from Marshall Paul from Defender General's office. Marshall, thank you for being here.
Thank you very much. Good morning, Marshall Paul from the Office of the Defender General. Obviously, we oppose this bill. We testified about this bill a couple of weeks ago. At the time, we said it was not the best nor the worst sealing expungement bill that you had seen, that there was some good parts to it and some bad parts to it. In the new draft, everything that we had identified as a good part has been removed. And there's been the parts that we identified as bad are still there. So I don't really have much to testify about that's new. I will say there's one part that's been added to the bill that I did not anticipate that I think is concerning, and I just want to touch on that. And that'll probably be the end of my testimony, which is on pages 25 and 26, there's new language that, from my perspective, really just exacerbates the inequities between the prosecution and the defense in just structurally. And so what this would allow on page 25 and 26, currently under current law, prosecutors and defense have the same level of access to expunged files, which is pretty much no access. Under the proposed law enforcement and prosecutors would have access to sealed files to peruse, to browse, to use essentially as a library. Defense attorneys would only have access to sealed files if they know the file exists in the first place, can go to a judge and request the file, get the judge to review the file and determine that the file is in fact responsive, and then turn the file over to the defense. So we go from a system where both sides have an equal amount of access to expunged files to a system where there's no expungement, and prosecutors have essentially a library of access to sealed files. They can review them, they can search them, they can search for files that they don't know exist, whereas defense attorneys have essentially the equivalent of interlibrary law. They have to know exactly what it is that they want to find, and then they have to request that. They can't just browse through and find it. And then once that they know what they want to find and they request it, there's somebody who gets to decide whether they get it or not. And so from our perspective, the main change that's been made to this bill, apart from stripping out the parts of the bill that we said were good before, is to add in this sort of structural inequity in terms of access to evidence. I submitted to Nate a law review article. It's a pre-publication law review article that I think is relevant to this issue and also to H193. And it's a pretty timely article. It just came out in February. It hasn't actually been published yet. It's released on SSRN for pre-publication comment. It's by Jessa Bowden and another attorney writing about the importance of separation of powers within the justice system, and in particular, the importance of having an independent defense bar, and particularly that independent defense bar has to be as independent as the prosecution. That when the prosecution has tools at its disposal that the defense does not have at its disposal, that creates real unjust and unfair outcomes, and in fact, inequitable outcomes. It results in more wrongful convictions and simply wrong outcomes when the defense doesn't have the same information that the prosecution have and doesn't have the same access to information that the prosecution has. So I don't have any other comments on the bill because I think everything else in the bill is stuff that I've commented about before. And I mean, I think it's pretty clear what the committee's opinion of our comments were. So there's no need to rehash that. I just wanted to highlight that one section because it is new language that was not in the as passed the Senate version.
So let me just ask a question then before I go forward. I want to clarify on something. So the Defender General's office, though, would be a criminal justice agency, wouldn't it?
No, we've never been considered a criminal justice agency. I think that I read that definition and I can see how you might read the definition of criminal justice agency and think the Defender General's office falls into that. But when you read the rest of the chapter, it's clear that it's not intended to encompass us because it's all about access to data and information that we certainly don't have access to. So that also would just be our office. About 50% of criminal defendants are not represented by our office. They're represented by conflict contract attorneys who certainly would not qualify as criminal justice agencies. Not only that, this doesn't take into account defendants have a constitutional right to represent themselves pro se, and a pro se defendant is certainly not a criminal justice agency and may not even know about the existence of sealed files. And as would defense attorneys not know about the existence of sealed files, whereas the prosecution under this law would be allowed to keep a library of sealed files that they could search through at any time to see what they could find that's relevant. The defense would not be allowed to do that. No other entity would be allowed to do that.
And this is specifically paragraph 3 on page 26 that's problematic.
It's, I think, the comparison between paragraphs, I think it's paragraphs 1, 2, and 3 of pages 25 and 26 together that cause this problem. Because if, for example, prosecutors and criminal justice agencies were given the same limitations that defense attorneys were, which is if you want access to the record, then go to the judge and request access to the record, which is what was in the Senate version, that would alleviate that concern.
All right, Karen, then Tom.
That was my question.
I'm trying to remember, whenever you need anything from, say, law enforcement as far as records go or anything like that, you simply send a letter requesting that and it's on game footage or whatever. And I'll supply that, correct?
So we can do that in the context of discovery. We can subpoena things like that. That doesn't mean there's no provision in here to allow us to subpoena a sealed record. Instead, it's this application to a judge. So when we file a subpoena, so when I file a subpoena, for example, I don't need a judge to say, yes, the subpoena is okay, or no, it's not. If somebody wants to try to quash the subpoena, they can go into court and say, I don't want to respond to the subpoena because I think it was defective in some way. And they can try to quash my subpoena. I file good subpoenas, so my subpoenas don't get quashed. But this doesn't
Trying to help you.
provide that. I understand that. And again, it would
I don't see that it would be if you were looking for the content of a sealed record in regards to a case, I don't see a problem with giving it. You could, because then, you know, if you're using it for a legitimate purpose, like hopefully everybody is, you would then be responsible for what happened.
Absolutely. I'm just saying this bill doesn't allow that. This bill requires us to go through a
You
judge
need to fix that.
We need to fix it.
in order to.
Yeah, it was in part a misunderstanding of criminal justice agency definition, but I think we clarified that. So yeah, we need to look at that language and fix that definitely. Okay. Other questions though for Marshall? Appreciate it. Thank you. Yeah, I thought that was. All right, so we'll go over to Jennifer Pullman next. Thank you for being here by Zoom, Jennifer.
Thank you very much to the committee. And for the record, my name is Jennifer Pullman. I'm the Executive Director of the Vermont Center for Crime Victim Services. And again, really appreciate the time that you're taking to hear from the center about S12. We haven't spoken on this bill yet, but I know you all heard from the center too many times to count on previous sealing and expungement versions. I do want to say just from the outset that the center does support the most current draft that is before you. Again, we've been an active part of these conversations and have worked quite closely with this committee and with all of our usual suspect partners over the years to try and move us forward as a state. And I'll continue to assert that what I see in front of me, which reflects a lot of what was passed out of the House in 655 last year, continues to, in the center's opinion, be a balanced approach to moving this issue forward. My plan this morning, I'll be brief, believe it or not, is to really focus on this most recent draft. And there were a couple of discussion points that were raised this week as well that I suspect are the driving force why I have been asked to be here. I'm happy to answer any questions at any point, but there are 4 areas that I do want to touch on. The first that I saw in conversation in this committee and what was asked of my colleagues is around whether we reconsider how we have structured Section 1 in terms of qualifying crimes. And do we revisit the way that we approach felonies to sort of mirror what we do with misdemeanors, which is we count everything except for this. Or these. And most of you were a part of this process last session. And remember the very deliberate, intentional scrutiny that went line by line and crime by crime over what was going to be included and excluded. And for the center, that process was really helpful. Again, all of us were heard quite a bit. And I felt like the landing point represented the conversations that took place. So we support the current proposal, but if there were to be consideration of flipping that approach to then go with all felonies except for, that would really require, especially at this point in the session, from our perspective, a lot more intention. You heard from Attorney McManus, you heard from Attorney Jones. It would really, again, need to take that space that we all took last session to look and comb through all of the statutes and the different titles to really think about what should be excluded. I think about, for me, when I think about the survivors that I work with and victims, I think about the parents who've had children who have died in Title 18 cases, that being the dispensing of drugs with death resulting. That's a felony. It would be my obligation to consult with those survivors about what it would mean if that could now be something that would be up for sealing. I think about, again, Attorney McManus and Jones already referenced the child sexual exploitation. So the list that's in Section 1 didn't come out of thin air. You all went through this process in a very painstaking way last session. And I don't know how much that was a significant consideration when it was brought up, but it would be something that I would ask time to consult with the victim survivors that I work with, and for, in the same way that we did last session, to have a chance to develop our own list of felonies that would be disqualified for consideration. So I'm just urging the committee to stay the course on Section 1. We didn't come up with the list out of nowhere. You all sat through, I can't even imagine how many hours of testimony to get to where we are. Second, I do want to acknowledge the question that Chair Lalonde, you raised with Attorney McManus the other day, or yesterday, around the victim's perspective in getting the messaging that could come from any of these changes. And I really want to thank you for that question. And again, what I thought I understood you were getting at is, what is the impact, or at least how I interpreted the question? What is the impact when our legal system makes, for me, an affirmative statement that something did not really happen? And while I always qualify most of my remarks when I speak about victims and survivors, and I try and speak on their behalf to say that they are not a monolith, every victim survivor is different and their individuality needs to be respected. In this case, I feel I could stake my career on this one. I feel comfortable that when we message somebody that didn't happen, that's devastating. And we already have spoken about, and you've heard from me, that the criminal justice system is not a friendly process to a victim survivor. They're only a witness to what hopefully is the worst day of their life, and that nothing else happens. They are a witness. They are not a party. They can sometimes be excluded from the courtroom because they are a witness. They have rights. We talk about them, but there's no recourse. And so I think about this statement that a young woman who I work with and who you've all met has shared with me when we think about victim impact and victim perspective. And it resonates with me. She said, she tells me, I don't get to earn time off my survivor sentence. I will never have the luxury of pretending this didn't happen to me. And you all have heard from Pam Harris, Roberta's daughter, about how it felt when she found out that what happened to her mom's body was not currently a crime in Vermont. And so I really do want to just, again, thank you, Mr. Chair, for the question. And we send messages when we make these decisions. And before we kind of go back and revisit the definition of qualifying crimes, again, I really would then caution that if we're going to do that, we need to give the time to really vet out what we're considering and what we're excluding. And briefly, as a related aside, the whole paradigm of listed crimes continues to be troubling to me because the purpose of it when it was initially adopted was to decide which victims of crime deserved a heightened level of victims' rights. The Victim Assistance Program was established. There were concerns about resourcing, how much time would be needed. And so it really was initially a very relatively small list, hard to believe, of crimes that would get a heightened level of victim services if you fell in as a victim survivor of that crime. But as we all know, it shows up in all different ways. And nothing underscores perhaps the lack of this as a default than what we went through in section 1 to talk about all the misdemeanors that are not included that this committee back last year thought should be included. So at some point in time, I think we need to think about listed crimes, but I certainly am concerned about using that as a default because it's not a default. If anything, it's a starting point, but I don't see how we can just rely upon that. With respect to deferred sentences, I'm not going to spend a lot of time on this piece. I understand it's very controversial. I understand there's a lot of concern about that. I've been around the building long enough to have opposed certain changes back in 2006 that expanded the kinds of crimes that could be considered. And so it's always interesting to me that I don't feel that old, but I see things circling back that I worked on. I certainly, do I prefer sealing over expungement? Absolutely. Do I recognize that for deferreds, yes. Do I recognize that there are serious crimes that are receiving deferred sentences for which we have zero record once they are expunged? Yes, that is the case. And I know it's been raised about whether this might impact the desire of a defendant to enter into a deferred sentence. And when I think about it, and I've turned this around in my head, if this current structure were to go through, the crimes that I'm thinking about that are concerning to me when I see a deferred sentence, namely domestic violence, sexual assault, there was a homicide. I think about those crimes, the fact that under this proposal, those crimes would not be eligible for sealing. So the deferred sentence, even if it were to move from expungement to sealing, would still be a significant carrot, would still be a loophole behind, as I see it, the policy statements that you're implicitly making when you've already carved out these crimes in section 1. So it's hard for me to understand that if this draft were to go through, that somebody who is facing the prospect of having a record that will remain unsealed in perpetuity would not take a deferred sentence and have it sealed. Because as we've spoken about over the past several years, the impact on the average person, whether it's sealed or expunged, all I have heard for the most part, not from everybody, is that essentially it's the same. No criminal history, no criminal record exists. And then finally, I did want to mention that one addition in the language that I really appreciated, which I found on page 28, and that's lines 15 through 17. Specifically, that's simply saying that holding an agency or entity accountable if for doing certain things if a record is sealed. And the restitution unit and the victims compensation program, which are both direct service programs that the center operates, do possess sealed records, but we don't know what we don't know. And I think often, and it worries me about our liability if we are treating a record in a way that because we don't know if it's sealed. We don't automatically get that notification. I was excited to hear from Judge Zoney yesterday, or maybe the day before, about the development of a form, and want to work with him to make sure that the restitution unit and compensation program are also identified on that form. But we are very responsible with our records. We don't often get requests, but it's certainly something that we might not find out till a month later. And I just want to be really thoughtful about that for our own purposes, and we want to do the right thing. And so I really appreciate the addition of that language. But that's all I have. I promised I'd be brief, and I hope I was. And again, appreciate the time.
Karen.
Yes, thank you, Jennifer. And Chair, I think this is relevant, but let me know if it's not, is I know that we have Willa here, and we're going to be considering moving diversion cases from expungement to sealing. And I'd be curious your take on that from a victim perspective. Correct? Is that correct?
Yeah, no, that's fine. Yeah.
Thank you for the question. Our general stance is we prefer that records exist for just that limited purpose rather than they just go away forever. Certainly, one of the things that we're concerned about is with restitution, if something is expunged, which it can be by accident, we don't have the recourse that we would like to be able to go back in and have a case reopened. But sealing, we can continue on in our own way. We have an excellent relationship with the diversion programs, and for us, again, I get nervous when I think about records being expunged. Certainly, I think that for me, the policy with diversion, or when I think about the intention, is to give folks a really solid bite at a chance of avoiding the criminal justice process. But if we don't know how many times somebody's been through diversion, that is concerning.
Thanks.
Questions for Jennifer? All right, Nazi, thank you very much for your testimony. Nice to have you back. We'll see if there's anything else the rest of this session to bring you in on in the next 2 weeks. See, I'm trying to will it to be done in 2 weeks.
But you just said 2 weeks. So.
I know. I'm trying to will that to be done. So anyway, so we'll go. Thank you very much again.
Thank you.
So we'll go to Wilda. Wilda, thank you so much for your memo and for weighing in. Good to see you.
Nice to see you too. For the record, my name is Wilda White. I am the founder of an organization called Mad Freedom, which is a civil and human rights advocacy organization on behalf of people who have been perceived to have a mental illness. We are dedicated to ending the discrimination and oppression of people who are perceived as having a mental illness. Thank you for allowing me to weigh in on this bill. I have to say I'm somewhat surprised that our organization is as interested as it is in this bill in general, but not after what happened in a couple years ago when because of something that happened a couple years ago, it's really our interest in this bill was greatly increased. We support the bill for the most part. However, we would like sealing to be extended to diversion cases. And it's because of our experience with the diversion case that we're asking for this change in the bill. a couple years ago when the legislature was considering a bill about workplace violence in hospitals. Much of the testimony assumed that the people who were causing violence in hospitals were people with mental illnesses. And this bill would have given law enforcement officers the opportunity to come in and make arrests solely on the word of a mental health professional. And we know, as people with psychiatric histories, that we're seldom believed. And that turned out to be the case when one of our constituents was assaulted by a nurse in an emergency room. She reported it to the police, and no one believed her. However, a videotape was later discovered which affirmed her version of the event. The nurse had said she had assaulted him, but the videotape showed clearly that he had assaulted her. Charges were brought against the nurse. The case went to diversion, and we wanted to bring this case to the legislature's attention when they were considering the bill, but we could find no evidence of it because the case had been expunged. This very much changed the policy discussion and altered and skewed that discussion and took away our voice and our history. As I said in my letter, our constituents are both victims of crimes and perpetrators of crime. And within our organization, we need to strike appropriate balance that recognizes everybody's rights and dignity and opportunities. And so while we fully support second chance, we also have to strike the balance and in favor of those who have been victimized and whose truths would be erased or are erased by expungement. Therefore, we've struck the balance of supporting strongly second chance through sealing. And we think sealing strikes the appropriate balance between giving people a second chance, protecting victims' rights, and making our communities safer. That's why we strongly urge you to extend sealing to diversion cases. The other thing I wanted to talk about was a direction of this bill that I also applaud and appreciate is the removal of the petition plus reasonable suspicion. I don't know if you know what I'm talking about. That's my shorthand. But in the Senate version, in order for law enforcement officers to get access to these files, they would have to file a petition in court and show reasonable suspicion. And I was happy to see that taken out because for a variety of reasons, a few of which I will touch on now. We're concerned about the delay that petitioning a court would take because oftentimes a sealed record might reveal a previous history of domestic violence and it could or assault. And that delay could mean somebody gets released on different terms because someone didn't understand the person had a criminal history. We're also concerned about the clogging the courts, because our judiciary is already backed up. We're also concerned about this undefined standard that was in there. Reasonable suspicion is not a standard that courts use. There's no case law on it. And we're concerned that when you have this undefined term, this undefined process, that you'll end up with uneven justice. And that's very concerning to us. We also think this safeguard is redundant because there are already penalties for this misuse of sealed records in 13 VSA section 7611. And so we would love for you to keep this House language in this bill as it moves forward. I'm also concerned just as a citizen, or not citizen, but a resident or community member in Vermont, that the message that the message that it sends to me as a community member in Vermont. Because when I listened to the testimony in the Senate Judiciary Committee, what I got was that the Senate Judiciary Committee, and I guess as endorsed by the Senate, don't trust law enforcement officers. And I feel like if the legislature doesn't trust law enforcement officers to use sealed records responsibly. It has a much broader crisis on its hands. Public police officers are entrusted with life and death decisions, enforcing the law and safeguarding the public. And law enforcement represents the government to the people. And when the legislature publicly signals distrust, it undermines the legitimacy of the state as a whole. And that's extremely concerning to me. I also think that sealing this petition doesn't solve a problem. It just introduces red tape. It just burdens law enforcement. It does not create accountability. It does not create transparency. It does not create an audit trail. It just slows things down, drains resources. And I think in the end, we're all less safe for it. So for those reasons, I really strongly encourage you to eliminate the petition based on reasonable suspicion in the bill, and then just to repeat, move towards sealing of diversion cases. And I'm happy to take questions if there are any.
Any questions? I don't see any. I think it's quite straightforward. I really appreciate testimony on both those points. So, okay. So we'll move on to Willa then. I appreciate that. Will, thanks again. Oh, thank you for being here. Nice to see you again.
See you all. Willa Farrow, Court Diversion Pretrial Services with the Attorney General's Office. So I'm gathering that the issue really at hand relates to diversion records. So that's all that I would speak to
Yes.
as relates to this bill. So under current law, as I think you all know, after somebody completes diversion successfully, the court, or 2 years afterwards, the court orders expungement, providing certain conditions are met, that all the restitution has been paid, doing this from memory, and that there's no other pending charge or conviction in the interim. I think that my preference is that we retain the expungement provision as opposed to going to sealing. I do think there's a qualitative difference between participating in court diversion through a restorative process where people really are taking active accountability for what they did, repairing harm. It's a very different process than going through court and having a sentence imposed and being found guilty. The benefits are to the individual for their feeling that they really have accomplished and can move forward. So my preference, in short, just keep my testimony brief, is that we retain the expungement provision for court diversion records.
So I know for petitioning for sealing, we have we divided what kind of cases can be expunged and what kind, or which kind could not be sealed or expunged, period.
Okay.
Would there be something to having something like that for delineating what offenses are going to diversion and certain offenses can be expunged and certain can be sealed? I mean, that may be a little more complicated. Obviously,
Right.
It is a lot more complicated than just sealing everything.
Right. That is a new idea to me. So off the top of my head, that is my first reaction is like how and what. Although I get into wanting to figure out the details. But I could see that there'd be merit to that in following the thinking that is the committee has in this bill.
Because I'm also concerned just what we passed last biennium, allowing certain domestic or sexual assault cases to go to diversion. Now, I know there's a lot of protections there, and I can't recall if we exempted those from being expunged or not. I don't think we did.
Well, interestingly, that legislation, which I refer to as Act 11 from whatever session that was, pertains to community justice centers. It doesn't pertain to court diversion. So there is legally no prohibition in court diversion, but for many years, we have a policy that prohibits the referral of intimate partner violence case for, I wouldn't even want to say the word case. So often, not infrequently, because we have a committee that reviews these referrals of, could be some sort of public disorder type of crime. But when people discuss and learn what's happened, there's intimate partner violence, and those cases are not accepted. It's not always a clear line what those are. Long-winded way of saying that the nature of a charge doesn't necessarily capture the dynamics in the situation. So, and also current law does not prohibit. The only prohibition of cases by charge to court diversion are listed felony crimes. Otherwise, it's up to the state's attorney. The prosecutor has complete discretion as to what they refer. But programs can choose not to accept.
So does the expungement occur at the CJC that's doing the diversion, the court diversion?
Yes. So when a case is an expungement order is issued, it is sent by the court to the program, to our office, to prosecutor's office, and law enforcement.
So how does a diversion keep track if somebody's repeatedly going back to diversion? I suppose if it's not successful, there's not any kind of expungement.
Right.
But if they go back and there is success, but they cycle through, how's that tracked?
It is not tracked. So our office, under current law, the Attorney General's office is to maintain an index of individuals whose court diversion cases have been expunged with limited information allowed to be retained. But local programs do not have records. They have memories. That's like prosecutors and others in the community. If it's 2 years, after 2 years. And usually it's longer than 2 years because the process doesn't happen quite that quickly.
Other questions? Yeah.
Can you just remind me, because I wasn't here for the diversion discussion in past bienniums.
Yes.
So pre-charge diversion is part of what we're talking about here.
Well, I haven't referenced that. My comments have been relative to post-charge diversion under current law. Come July, Act 180 will go into the provisions, certain provisions of Act 180 passed last year will go into effect this coming July pertaining to pre-charge diversion. And in that legislation, there was the use of the word deletion of records for pre-charge diversion because they aren't court records. They're only law enforcement records and program records. And so the committee chose the word deletion to capture the same concept. I think that's important that, these are not, they're crimes, but they have not been entered the court system. So I think the deletion concept is valid. However, there are parts of that law which are cumbersome administratively that I could go mention, but I think it might be outside the scope of S12.
I guess, are you thinking about pre-charge as well?
I am thinking that we're too late in the session to figure out all of the different document issues and diversion, be it pre-charge or post. But I come from a position that I think they should be sealed. But to get there, we have a lot more work to do, and we need to hear from some CJCs. We need to broaden what we're hearing. And I think in that process, we should look at the pre-charge diversion as well and what we're doing there. I just think that that's a bigger issue than we have time for. So this will be one of my first bills I put in for bill drafting request for next year.
For pre-charge, post-charge.
Pre-charge and post-charge,
Okay.
just to deal all of it together once we have the new law in place come July 1st. Because I think this is a little too much to try to put in here since I had been hoping of voting this bill out tomorrow or Tuesday at the latest, because just timing wise, it has to come out. Just in case we are done in 2 weeks.
Would anything pre-charge be applicable to this?
Well, that's what I
Because
mean.
it's not even a conviction.
Right, right. So how do we deal with the documents in pre-charge? But I think there should be some document retention there of some sort as well to see who was coming into that system. So that's my kind of initial reaction. I'm happy to hear other viewpoints if you think that we are.
So I can go without definitely for pre-charge. I feel like post-charge is a little bit cleaner and already involves the court. So I could see it in this, but I also see the benefit of just putting all diversion things to next year. I'm flexible.
So I mean, if I had two main witnesses coming in saying, yeah, do it, then it would be one thing. But there are obviously, I'm seeing that there are different views of how to proceed with this, and we're going to need to have much more testimony to figure out what to do with diversion. Though, I will probably put in a bill request, which will have the assumption that we are moving to sealing, and I'll figure out, just to put it out there for us to consider.
And I could certainly, in the coming months, gather information from providers and both around pre and post-charge diversion and gather more information
Yeah.
and
So,
share that with you.
all right, anything else on that? So just going with just a kind of an update on folks. So I'm going to talk to Michelle about the latest and hopefully have a draft that we can look at and possibly vote on tomorrow. We'll see. I don't know who else we necessarily have to hear from. Am I missing any? I don't think we're missing anybody. So just if you have your draft number 1.2 on page 24, given the input from just page 24 was another place. Actually, on page 15 and page 24, Judge Zone suggested saying Vermont state entities, for I'm going to talk. I don't know if we resolved whether we wanted to ask the court to come up with a new form for that or not. Did we resolve that?
About like when a petitioner.
Yeah, so that we'll have check off of all the different places that they.
I thought that's where we were going, but
That we were going to put in there that the court shall provide a form.
yeah. Also, how are you gonna fix the Marshall thing?
I don't know, I was hoping you would figure that out.
Okay.
And we can talk to Michelle
Yeah.
as well. Right, let me see, consider form. State entity. All right, so then we're gonna get some language. I think I do understand what Kim McManus was suggesting, of including in the exceptions in C, number 2 on line 9, and then having some separate language in subdivision C2 along the lines that prosecutors before using these documents in court, or something along those lines, that the court has to find that they are relevant to a criminal justice purpose or something like that.
Which then kind of gets back to what's the purpose of just C then?
And then we should think about what the purposes are.
Yeah, because like then we're just like have exceptions to all, like everyone is an exception.
Well, yeah,
I guess it would just, yeah, I don't know.
so we're gonna need some further thought on C in a broader sense. Maybe sit down with Michelle as well, but just to kind of figure that out. But yeah, we do have to figure out the defense attorney. I mean, they should have equivalents.
And one thing that didn't come up,
I was just gonna say, I agree that we need to rework that language, and I also heard you say maybe a vote tomorrow. I feel like if we develop a new language, we need to run it by those entities before.
Yeah, we do. That's true. So vote tomorrow is probably unlikely.
Okay. Just put
But
that out there.
but it's, yeah, we need to get it out. But maybe this is, if we get to this, if we get to the point where we're starting to run out of time and all that, and I'm anticipating that we're gonna have everybody on board, I'm hoping. But that's my intent, to keep on trying to find a way that we're all on board, or most of us. Then we might be able to suspend rules to move it more quickly, so we can get it over to the Senate, so they can ask for a committee conference. So yeah, it seems unlikely that we'll be voting this on.
All right, very good.
Anything else that I'm missing on that? Miss anything? Zach, anything?
There was one I had.
Anyone?
I think Michelle already
It's a
captured
savings
it.
clause. Well, I'm calling it a savings clause, but with respect to the deferral, any pending deferrals.
Oh, yeah.
Anything?
Yeah, scrap it, let's start over. No, yeah.
Yeah. Yeah, we can start from the beginning. We have a motion, is there a second?
To scrap it? It's what the administration very much wants. Trying to work with the administration, it's a huge part of Ken's favorite bill, H411. It's like 40 pages of that bill.
Well,
Is this.
so we're not adding anymore.
No, I was exploring,
Okay.
I was just
No.
trying to understand.
There,
No, I mean, well, it's, if there were gonna be crimes added, if I'm trying to get unanimity, I would have to make sure everybody would be on board with that, and that seems unlikely. There's a welfare.
no felonies. How did this list of crimes like get here originally?
I believe, if my memory serves me right, it was initially from the Sentencing Commission.
Some committee came up with them.
Yes,
Okay.
Sentencing Commission provided that, and then we did look at individuals, we looked closely, and people suggested additions, subtractions, and that's where this landed. But the thing is that it's kind of interesting, and I will just raise this, but I'm not gonna push this, that this, it really is focused on the felonies in Title 13.
Yeah.
But there are felonies throughout the titles, including, well, welfare fraud, that's in Title 33. We don't have that included. There's taxation, false or fraudulent returns. That's also a felony, and failure to pay tax or file tax return is actually a felony.
So why couldn't that be one of the two?
Why couldn't we add something like those
Yeah.
that are nonviolent?
We're running out of time.
Well, because
The bank won't like those.
Well, they already don't like.
No, that's true. That is.
so, because like Ken McManus suggested that it's a nice balance now, I guess, but
Running out
all
of
the
time.
rest, there's, all right, a felony under Title 23 autos, false name, address, material false, something, I'd have to look at what that is, but that's a
So
felony.
did the Sentencing Commission, is that what it was? Did they look only at Title 13?
Hold on, I can pull up the report.
Because there's one title 18 that's included in this.
So based on that, you're assuming they looked at all of them.
No, I'm not.
This is a starting point, and from here we can expand and grow.
So you think that we could add more felonies into this?
Let it ride a little while, see what happens.
That actually could happen.
Tom said.
Especially if we get it.
We're learning all about unintended consequences of our legislation from time to time.
Wait,
It wasn't,
Oh, I don't know, Wilda brought some stuff
it's a
up.
joint legislative committee,
Things.
joint legislative justice oversight committee in 2021.
So we're basing all of the sealable felonies on commissions that none of us were on that happened in 2021.
You were
no,
the last biennium as well.
You were on it. Do you remember if you looked at all the titles?
There's this report I can send to everybody.
Oh, you have the report?
Yeah.
No, I agree that, we're,
The starting point.
Great.
well,
As is.
It's the best opportunity to expand the number of offenses because.
In this moment.
Probably. Yeah, maybe. All right, so we have this afternoon. Do I have this? So we have an amendment to look at for 109, the miscellaneous bill. And I think it has now been posted. It's the things that were coming in at the last moment and afterwards. And we have some testimony because there's some disagreement on whether relief from abuse petitions should be part of the last section in the bill related to representation, the representation for families and children in Chin's cases. And we have some different viewpoints of that, so we want to hear out some witnesses and decide what to do with that. And we'll look at the other. I think everything else as far as the amendment, I don't think we need to have other people in because I think they're relatively straightforward. It's adding the Attorney General's office and the Department of State's attorneys at their request to that to one of the committees or working groups. There's a language that DCF did provide. If you recall, when DCF testified on that one provision, as far as whether payment of child support should be part of their process for termination of parental rights, they wanted to make clear an exception that DCF does not look at that, and we have that language. So I don't think we have to bring them back in because they told us that they were going to give us that language and explained it to us. So I think that, and then there was one other change that Ann Donahue suggested for the guardianship report, which again, I think the witnesses mainly are for that one issue that's kind of still haven't figured out where we should go with. All right, anything else?
Committee amendment? Or someone
It can
offering
be, I mean, it can be, I think it has to be individuals, but if individuals,
it seems straightforward.
yeah, I mean, we can all decide who all wants to be on it or, but it can be everybody.
Ken can do the whole thing.
Well, I haven't given him a.
I second that.
You already gave him an assignment or?
No, not yet, not yet.
Yeah, he could do, he's.
I was waiting to see how yesterday went.
It doesn't even get any pushback.
No, none.
Yeah, do you want to do the amendment? Yeah. He's ignoring me. All right, let me just double check to make sure that I got that right. So yeah, so it's actually, we're not going to be long, I don't think, this afternoon, I hope. So S1